Good evening. To get started, thank you for joining us for this information session on what's next for TPS recipients. Today, we're going to tell you a little bit first about CUNY SPS, and then talk about policies regarding DACA and TPS, and then at the end, time for some questions. So, introduce myself. My name is Dawn Pickin. I'm program director here at the School of Professional Studies. I am joined today by our main presenter, Mark Drucker, who is a practicing immigration law attorney. He teaches in our immigration law advanced certificate program as well. And we'll be hearing from Mark in just a minute. But I wanted to tell folks about our immigration law certificate. So just a little bit briefly about school, if you're not familiar with us. CUNY SPS offers bachelor's degrees, master's degrees, as well as certificates at the graduate and graduate level. Our immigration law certificate program began in 2005, so around a while. We offer classes in this program online and in-person format. Don't need any prior immigration experience to take this program, but you do need to have a bachelor's degree. The advanced certificate is a graduate level program. So this program, as all of the programs here at CUNY SPS, are faculty teach to adult learners, and faculty that teach in the program, they're all practitioners in the field, so practicing lawyers, judges that do this work every day, their experience into the classroom. A lot about what's going on in this ever-changing. If you are interested in learning more about the program, we're actually going to be having an open house online only, and that's to be on May 16th at 12 o'clock. So sit at lunch and join us for that webinar. If you want to register for that, the slide here has the website address. You also have some materials that have the address to register at. And so with that, I'm going to turn it over to Mark.
The reason I'm doing this, talking about it, is because people are very upset about not knowing what their future is going to hold. They've been here a long time. Certainly the people with TPS have been basically Salvadorians have had TPS, I think, since 2001. So they've been basically here for 17 years with employment authorization. So now all of a sudden they have to scramble and find some other way to stay here. So that's what we're going to be talking about tonight. Basically, where we stand now is kind of nowhere. I mean, I don't see any bills in Congress at this point that's talking about extending or dealing with the TPS issue. There was a little bit when the president said, yeah, he wanted to look for or was willing to sign a bill. That never came to fruition. So back to square one. I don't want to get into the politics of immigration because people are on all sides. But the groundswell, I think, was amongst the American population is what these DACA recipients should be able to stay here. I mean, and then there's a lot of disinformation about what is a DACA recipient. I'll meet people on vacation, they'll tell me, oh, how come DACA people can't get their citizenship? Well, what's the problem? They don't realize that DACA recipients don't even have a green card. They basically are allowed to stay here, but they're still illegally here. So they don't really have any other status other than the fact that they're allowed to stay and work here. And it's generally for 2-year increments. So how did DACA come about? What brought this DACA provision? And clearly it was because I think President Obama was very frustrated with Congress. He had proposed some legislation, a comprehensive immigration reform bill that was approved by the Senate. I think it's a consensus that this should go through. There was a consensus basically that immigration needed reform, needed to change things around, and certainly the young people who would object to giving young people the ability to stay here and work. And then, you know what happened, right? Nothing happened. So basically, he issued this executive order, which is not a law. It's an executive order that allows for what's called deferred action. There's a lot of misunderstanding about what is deferred action. And some of the courts said, well, that's unconstitutional. But I tend to disagree. I think there was a number of times when I went before immigration, someone was in deportation proceedings, you would ask for deferred action, and they would grant it to you. So it's not something that was totally off the wall. Deferred action was granted to people who had some kind of hardship here. They had children here, and they were granted employment authorization, usually for a year. And they go back and they got again deferred action. So when President Obama said, let's put this into some kind of executive order, he said, we're just going to defer action for these people who came here before they were age of 16. They had a clean record. They didn't have any serious misdemeanor or a felony, or even a DUI. They had to show they've been here every year, proof, since 2007. This is basically what is required for DACA. And a lot of people, I think, were under the impression that people coming in from the border can quickly come in and apply for DACA. That's crazy, right? This is what you have to have. And they had to be under the age of 31 on June 15th, 2012. Some people just missed out on that. Had to actually be here illegally, and their lawful status had to have expired before June 15th, 2012. They had to show school records from early on that they've been here every year. So they had to show vaccination records. They have the transcript from their school, from high school. They had to show that they either had a high school diploma or that they were taking a GED course or had passed a GED. So it wasn't something that quickly anybody could apply for. They were pretty strict at looking at all your documents, making sure you had the physical presence. Again, if you had any kind of criminal record, you weren't qualified unless it was a minor disorderly conduct. So basically, that's what DACA is about. There was another proposal that was called TPS. I don't know if you've heard about that. That was deferred action for parents of U.S. citizen children. And that also was an executive order that President Obama put forward. And what happened to that? Well, there's a Court of Appeals case that came out of the Fifth Circuit that basically said that's unconstitutional. That died. Okay, so that never came about. But DACA has been, a good program. But when President Trump was running for office, what was one of his major slogans was DACA was illegal because President Obama didn't have the authorization. It wasn't a law. So when he became president, he basically said, I'm going to rescind it. It's not there. Congress has to come up with something to prove DACA or allow DACA to exist. So we're up to now basically what's going on with DACA, and that's where we're talking about. So there's been a couple of cases. So that has to go for judges giving 90 days to the Department of Homeland Security to explain its reasoning. So right now, under two quick cases one out of the Federal District Court in California, Regents of the University of California, that was decided January 9th, 2018, and the Ninth Circuit, and one out of Brooklyn, Italia Vidal versus Nelson, that basically said that DHS you have to accept DACA extension requests. So now, and the USCIS said, yes, you have to take them. So people now can apply, and I'm telling my clients to apply right now. Even if you have 6 months or 8 months, apply now. And not rejecting them. Don't wait to the last minute to apply, because we don't know what's going to happen to DACA. But if you apply now, you're going to get to 2 years. So that's number one. You got to apply now. If your DACA expired before September 5th, 2016, one can request DACA as a renewal, can file it as an extension. So that's a big thing too. You have to see when your DACA expired. Some people waited a long time, think they were going to get residence through some other means, and they didn't. So you got to check your date of expiration. It says here between 150 and 120 days before expiration, but I don't believe that. I think they're going to take it any time. So I'm getting clients, and you're getting the full 2 years, and you'll get your work authorization. So that's very important to do. Thing you can't do now is get advanced parole. Everybody, I think, probably knows what advanced parole is. It's permission to travel outside the United States, to go home and come back in. When you come back in legally with a parole document. So that would cure your illegal entry that you may have had when you first came here. That's very important. But some people didn't have the advanced parole, and now it's too late. Okay, so you can't have your client now try to get advanced parole or even try to leave the country. It's very dangerous. So I would recommend filing, telling you if you have DACA, apply for the extension as soon as possible. I don't know if anyone saw in today's paper, it was yesterday, I think the state of Texas, 5 other states have now sued the government to end the DACA program. All right, they filed a lawsuit against the federal government and federal district court challenging the 2012 executive action that created the DACA program, and it seeks an injunction against the issuance or renewal of any DACA permits in the future. Well, this is very troublesome, not only because of what it says, but guess where it was brought? Same place where the DAPA case was brought. So that was in Brownsville, Texas. And guess what? There's only one judge, federal district court judge in Brownsville, Texas. And guess what his feeling is about immigration? So this is going to be problematic, because if he gets this case, and it looks like he will, you know how he's going to rule, and it's going to go back up to the Fifth Circuit. And I think we know how they're going to rule. So we may end up seeing the end of DACA, even with these federal court cases. So that's the word of wise. That's why I'm saying file DACA as soon as possible. Okay. We don't know how long this case is going to take until it winds its way up until Fifth Circuit, and then it may be challenged to get into the Supreme Court. But we even know now, I think, how the Supreme Court is going to rule on President Trump's travel ban for certain countries. So if that's the case, I think it's going to be not a good one for DACA recipients. Before I give you some alternatives, I also want to talk a little bit about TPS, because that's another area. Okay, so TPS it's a very different animal than DACA. Everyone should understand why. TPS is a law. Okay, this was enacted by Congress. It's part of the Section 244 of the INN Act. So you could read it if you have your Immigration Act. It's right here under Section 244 status. So that is something that cannot be challenged in court. But the problem with TPS is that it's the Attorney General is granted pretty much sole authority to designate which countries are eligible for TPS and should be granted. So what does it basically says? They have to show there's an ongoing armed conflict with the designated country, requiring the return of aliens who are nationals of that country, would pose a serious threat to their personal safety. But what's one country you hear about all the time? That's one of the few countries I think that's still getting TPS, and that's probably Syria, right? But we're all hearing now that Salvador, we talked about, Honduras, on TPS for El Salvador is basically going to be extended only until 9/9/2019. Then it ends. You can apply now for still an extension of it, get your work permit. I even had someone come in yesterday, which was very interesting. They actually got advanced parole, came back in last week. So I was very surprised that they would give them advanced parole knowing that the TPS is ending. That was a very interesting because now that person has a legal entry and she's married to a citizen, so she could maybe adjust her status here. That makes a very big difference. So if you have TPS and you can show that there's a reason, a humanitarian reason why you have to leave the country, and in this case, she only said her aunt was very sick. She was able to get permission to leave and come back, and it really made a big difference now, I think, in her case. Honduras basically is extended, and you have to file. I think the time for filing that now is over. But they haven't really made a decision yet on that. Haiti, I think we all heard about Haiti's ending of TPS, but there's an 18-month grace period to allow for transition, they're saying. So people from Haiti can get, I guess, extension of TPS, but again, it's ending. Liberia, that's going to be terminated as of 3/31/2019, so that's about next year. So only one basically that is still going to get it is Syria right now. I just saw yesterday that we got a notice that TPS for Nepal has been terminated. So that's an interesting situation because when we talked about what is TPS, talked about armed conflict. There's also an issue of what happens if there's a real severe earthquake or natural disaster in your country. I think that's basically what happened in El Salvador, was that they had I believe it was floods and earthquakes, and that basically made it so difficult for people to come back, no home to come back to. So they basically said, okay, you could stay, and they kept extending and extending, even though you knew that things had gotten better there. So this is where there's a little bit of, I don't know if you want to call it hypocrisy, but basically to say now it's after all these years, things have changed. Well, yeah, things have changed, but things changed about 10 years ago, not the last year or two. Foreign country must request TPS designation for their aliens living in the United States. Basically, there's an application that has to be filed with, it doesn't cost anything. The only thing that costs is the fee for the employment authorization, which I think is $410. Now, clearly in Nepal, they had a big problem with, I think it was earthquake. And again, it was a big mess there. And therefore, they gave people from Nepal permission to stay here. Okay, what does TPS give you? So it gives you basically protective status, permission to stay here, work here. You get an employment card for at least a year, sometimes it's 18 months. Get the advanced parole to travel. You could also apply for asylum. All right, so a lot of people from El Salvador and other countries where they were afraid to go back to said, yes, so we want to apply for asylum. You can do that also. Then I put down here, may apply for cancellation of removal once the TPS expires. So now I think everybody wants to know, and this is the crux of this program, is what are our alternatives? What are our options, right? The one that most people want is to be able to get their green card here, right? Just their status. So there are basically a couple of options for that. One is the Section 245A. You have to show that you're qualified. You have to have an approved petition or a petition filed on your behalf. So have a spouse file a petition with you, for you, or if you have a child that's over 21 that was born here, that child file for you, or if you have a parent or even a brother or sister who filed for you years and years ago with a priority date that's current, might be able to uh, file for adjustment of status. The two areas I think that are most interesting is paroled in place. We talked a little bit about parole and basically people who are getting advanced parole through the TPS or through DACA, right? But they could now adjust their status because they had a legal entry if they have an approved petition. Parole in place is more interesting, and I don't know if anyone knows what that is, but that's basically a decision that came about a few years ago. It was military families called military parole in place, where if your son, stepson, spouse was in the military, even if it was in the National Guard or reserve, active duty reserve, you could ask for what's called parole in place. And I haven't lost one of those cases. So if you get the parole in place, you don't have to leave the country. You're doing it all here, but you're getting an I-94 showing that you've been basically paroled into the United States. And with that parole in place, you can then adjust your status based on a petition. The other type of parole is not military, but if you could show, and I think I haven't tried it yet, but there's some real humanitarian reasons why you can't leave the country. You could ask for a parole in place. And I'm thinking maybe if you have a very sick child or your spouse is very sick, you could try it. It doesn't hurt. You go before the district director, you make this request, and it might be granted. So I think it's worth the shot if you can do it. So under Section 245A, you could get your green card here, and it's pretty quick. It's taking about 9 to 10 months in New York and New Jersey to get your interview. Generally under the Trump administration, everybody is being interviewed, even professors, and they're interviewing people who never were interviewed before. Now, the second adjustment of status is under Section 245I, and that's a very tricky section because it requires you have to have a petition filed on your behalf before April 30th, 2001, and you had to be physically present here on December 20th, 21st, 2000. But there are a lot of exceptions to this. So if you're married to somebody who had the 245I eligibility, you would be able to get derivative status. If your mother or father had 245I, even though they never got their residence, and you were under 21, you would still qualify for 245I as a derivative. So I had recently a case in New York where I had to explain to one of the supervisors in the 245 section how grandfathering works, because they're they're taking people from different sections and they really don't know that much about the law, and this is a very confusing part of the law. So you may have to explain to them what derivative status means. And you don't have to be under 21 at the time that your spouse became a 245I eligible, or even marry him before that. So I suggest either read up on grandfathering 245I or take a class. But it's very important. If you qualify for 245I, you really can just have to pay $1,000 and you get your green card here, which I think is much more preferable. A lot of people had in certain countries, where in particular Mexico, where you had to file, their line is 20 years behind for a married child or a child or a resident. So people have filed maybe for their from their uncle or from their aunt, for the parents, and they've been waiting a long, long time. Well, these people may be eligible for the 245I also. They could have been grandfathered. So something to think about and check. Next option is basically, say you're married to a citizen, your parent is a citizen, and you came in illegally. You want to get your green card, right? But if you didn't have the advanced parole, you're not eligible for parole in place, what can you do? And a lot of people say, well, I don't want to go home. But there is an option. And that's something that was passed. This is a law. It's in the Act. It's called the I-601 waiver. It's a very, very good waiver. 601 was a waiver, but you had to file that when you were abroad. So the council would say, okay, you're going to Ciudad Juarez and the Ciudad, well, you're subject to a 10-year bar. We all know that basically if you're here illegally for more than 1 year, the minute you leave the country, you can't come back for 10 years, right? That's the law. And the 601 basically waives 10-year requirement, but you have to show certain your eligibility. And the eligibility standard is pretty high. You have to show extreme hardship to a spouse who's a resident or citizen, or to a parent who's a resident or citizen. All right? But the beauty of the 601A waiver is that it's done here. Okay? So you apply for the 601 waiver after your petition is approved, after you're all ready to visa process, submit this I-601A waiver. And if it's approved, then you could go home to whatever embassy you might be, whether or not it's Bogota or San Salvador or Paris, wherever it might be. And generally you can come back in a week. I've had everyone come back. I haven't really lost anybody on ones who they've had the 601A waiver. Now, in order to really present a good 601A waiver, how do you show extreme hardship to your relative? Okay, and that's what really, good lawyering or packaging does. Generally, the first thing I do is tell my client their citizen spouse or parent has to have a psychological evaluation, show what kind of hardship they're going to suffer if their spouse has to go to Mexico or to Haiti or to Salvador. What's going to happen to them, and how are they going to be able to live here without their spouse, or how are they going to live there for 10 years with their spouse? So that's very important to get a good detailed psychological evaluation. That's number one. Number two is you have to establish that someone's going to suffer hardship because either they have a child here, and what are they going to do with the child? You can't show the hardship to the child. You can show how the hardship of the child will affect U.S. citizen or permanent resident parent, right? So say you have a child that's got bad asthma or has some kind of disability. Well, what's the parent going to do? If your spouse has to go to Mexico, you want to go to Mexico with your spouse, what's going to happen to your child? He's not going to be able to get the care or the treatment that he's going to get here. So it puts the parent in a very awkward and terrible position, right? They have to know, what am I going to do? What's a terrible, terrible situation that sometimes you have an older parent who may have dementia or a problem. And you show that too. I can't leave my mother or my father here because they really need my help. I help administer drugs, or I take them to the store, I support them. So that's all very, very important to establish. Uh, so the 601A waiver is very, very important. If you have no option, if the 245A or the 245I is not available to you, you can look into that. The next we have is employment-based option. Now that a lot of people come in and say, well, my employer wants to sponsor me. Yeah, that's great. You have to get a lot of people, their residents, through a sponsorship to a restaurant or HVAC repair or all kinds of jobs. And you go through the labor department, you establish that the person has a real skill. You can't find an American worker to replace that person, right? Whether it's even a home attendants, housekeepers, it used to be run the gamut. But that's become problematic now because you can't adjust your status if they're here illegally, and they're not eligible generally for the 601A waiver because they don't have the necessary family tie. They may have a child here who's a citizen, but that doesn't give them the 601A waiver. Everyone, I think, hopefully understands that. So employment-based option is an option, but sometimes it's really not. I'll tell clients it doesn't pay to go through the whole process. It's an expensive process. You have to advertise the job, show there's no American worker available, and you're talking about thousands of dollars when at the end, where are they going to go to get their green card? That's what I try to say. Where can you go? If you leave the country, you can't come back, you can't do it here. So there's that issue. A lot of people coming in, and I think probably know or should know about the U visa. There's a U visa and a T visa, right? The U visa is more common. Basically, it's for people who have been victims of a crime, right? Get a lot of women who say that they've been abused, and sometimes that's considered a crime. But you have to establish that there's a serious crime, has to meet a definition of what the crime is. You have to say that or show that you helped in bringing this person to justice, that you helped the prosecutor in convicting this person. So you have to show cooperation with the district attorney's office, right? So the district attorney has to sign off on the form. It's a 918B, I believe. 918 Supplement B. So if you've been a victim of a crime, but never really went to the DA's office, you never really helped anybody, you're not going to get it. But I just had one recently where we did get one. And this was an interesting case because it was a mother of a child who was at a park with her child, and the child was on the swings. Some guy came up to her and exactly what he did, but he was kind of a little perverted, started touching her, and she screamed, got the police to come, and I guess he's doing it to a number of children around, and they ended up convicting him on her testimony and everything, and he's in jail. And because she's the parent of a child, she's entitled to a U visa also. So she got the U visa. The U visa is good for 4 years. He gets a work authorization. The beauty of a U visa is that even if you came in illegally, you could get your green card here. So that's another way around the 245 requirement of having to show you had a legal entry. And you can get your green card after 3 years. But there is a limit to the visas, so sometimes you have to wait. There's a lot of people applying now for to get one of those 10,000 visas. The types of crimes really vary tremendously. You'd have to look it up, but you do have to show physical. If you abuse, someone could hit you on the head or tried to rob your store or did something, tried to mug you. As long as you can show that you had physical injury or psychological injury and that you helped the district attorney, then I think you might qualify. So it's a good thing to try to do if you can do it, or even if you had a child that had this problem, I think it's something to look into. T visas I'm not going to talk about them too much because those are basically victims of trafficking. okay? And that's basically sexual trafficking, that people brought them in to work at a brothel as a prostitute or whatever, or there was some that came in as indentured servants, uh, servitude. There was a number of them, I think, came out of China at one point, and they basically said that you had to pay off the smuggler who brought you into the country for a certain number of years. And they had to work in these restaurants and things, basically as slaves, until they paid off, called snakeheads. So that was really, again, they were victims of trafficking. And if you could prove it, they would also be entitled to a visa. There's a certain number of visas available for traffickers. So 5,000 visas per year. And have to show basically your severe traffic going on. So there are certain organizations that help in dealing with T visas and certainly with U visas. So these are options that I think you might want to look into. Political asylum. That's a very interesting area, right? Everybody knows what political asylum is. Under the new Trump rules, they're taking people who applied now, giving them interviews first. Why are they doing that? I think that's to stop people from applying for political asylum because they're going to have deportation proceedings brought against them if their case is not approved. So anybody who goes for political asylum, and generally, unless you've got a really, really strong case, they can issue a notice to appear in immigration court. Then you have to see an immigration judge, and you're facing deportation. I know it's not something. I mean, clearly, if there's you're from a country, maybe Syria or Iran, Iraq, where there's been real problems or changes in the last few years, you might want to pursue it. But it's a dangerous thing because you're going to be placed in deportation. So you're exposing yourself. The employment authorization, you do qualify for a work permit after 180 days. But because of this new policy now, they're giving you hearing right away. You're not going to have the 180 days. So you might not get the work authorization, right? So that's the only reason you might want to do political asylum because of this case. This section of the law is called cancellation of removal for non-permanent residents. And in order to do this, you have to be placed in removal proceedings. So this is an area where you can get permanent residence without having to leave the country, without having to do a waiver, without having to do anything. But these are some of the requirements. So you have to have 10 years of continuous residence, must be a person of good moral character, no aggravated felonies. Then the hardest part, which is some judges view it differently, is letter E. You have to show that the removal would result in exceptional and extremely unusual hardship to the alien spouse, parent, or child who's a citizen or lawful permanent resident. So what does that mean? I had a judge recently who denied my client's application for cancellation. And the child had kidney cancer from the age of 4, came back at the age of 10. Now she's in remission. So the judge says, well, you're in remission, you can go home. And we'll take an appeal right now. But again, it just shows you, and most judges would never rule that way because we all know what remission could be for a year or 2 years and then come back again. So, and yet I had another judge who the child had asthma and they granted cancellation of removal. So you run all over the place. So a lot depends on who the judge is, like anything. But it's something you really might want to do. Certainly if you have a child, I'd say if you have a child that has autism or on the spectrum, those are strong cases because generally most countries don't really have programs and education for children like that. So that is something that you might want to look into. So that's cancellation of removal. Only other thing I have here is Violence Against Women Act, and I think people know what that is. You have to really used proof that you've been abused as a spouse, and then you could qualify again for permanent resident status. And then the last, number 9, is deferred action, which now they're not granting anymore. Go to deportation with the strongest case. Generally, they're going to say you have to go. For arresting people on the spot at immigration, you go in for this. Very risky now to go down to immigration on any case because they could lock you up. Okay, we've heard it. I'm sure you've read 2 people going down on a marriage case. The good marriage, they approved the petition, and lo and behold, someone from ICE is waiting outside the door to arrest them because they had an old deportation order 20 or 30 years ago, and they're finding things now through the computer about old cases. I don't know how much time do we have for questions. Is this? Okay. Yep. So we have on the board here CUNY Citizenship Now. These are some of the resources. Are they going to be able to see this, Dawn, or? So they could see all this, right? Okay. So these are basically the resources. There's a number of organizations that help people who are victims of crimes for the U visas, for the T visas, like I said. There are, I think, Legal Aid Society that will help people who have really very interesting cases. Yeah, so anyone here have a quick question or a question that I tried to cover or I didn't cover? I'm in the back. Yeah, anyone, the question was, can someone who has an H-1B visa would be eligible for DACA? With a DACA, could he now change status to H-1B? Generally, no, because you have to be legally here to change your status, right? You have to be in status to change status. Someone who with DACA already says they're illegally here. So you couldn't change your status to a student or any. It would be wonderful if you could change to like an F1. Maybe someone TPS, if they never were illegally here, could, but not a DACA. That's just, so the question is, if someone has DACA and they end DACA, would they be placed in proceedings, or would they be placed in proceedings and removal proceedings? That's something we've talked about. According to the latest number, I've seen 700,000 people with DACA. I don't know how they would go about it. I mean, clearly they do have your address. They have all your information, whether they would start calling you in. I don't know if they have the resources to do it, but sure they could, because you've already admitted that you're illegally here. So I can't say no, they wouldn't. I just don't know when. Clearly, our Attorney General is someone who wants, and I think he's always been someone who wants to basically rid the United States of anyone who's illegally here. I think that's his thing. Has the DACA renewals under the new policy been renewed? And yes, I've seen a couple of my clients already get 2 years. Yeah, the question is, if the legality of DACA goes to the Supreme Court, how long would it take before they reach a decision? Well, that's really the only case I think right now would probably be that Fifth Circuit case out of Brownsville, which go to the Fifth Circuit to the Supreme Court. You probably talk about a couple of years, I would think, unless they want to expedite. So I don't see that as something immediate, but I don't know if the Fifth Circuit, how they would rule. Would it go countrywide like they did with DAPA? Say no, you're not allowed to accept any more applications or extensions. So we don't know. We don't know what that Fifth Circuit's going to do and what their decision is going to be. Even yesterday, I read that the case out of Brooklyn Federal District Court, I think now is going to go on appeal to the Second Circuit. So there's a lot of litigation going on, and unfortunately, Congress isn't really doing anything right. I don't know why, but it seems like someone has dropped the ball, and no one is proposing any changes. Yes. Yes, you can apply, clearly. Oh, sorry. If you're a victim of gang violence in your home country, can you apply for political asylum? So if it's been more than 1 year since you've left your country, there's a certain rule that basically says you can only apply for withholding, not asylum. All right. Withholding is a form of asylum, but it doesn't give you all the rights. It allows you to stay here, you can't travel, and it's much more restrictive. But if you could show that, yeah, you're afraid to go back because the government can't protect you against these gangs, I think you might have a case. But the cases coming out of El Salvador, and I think most of them claim that they were, afraid of these gangs, and Mexico in particular, the drug cartel. I don't think they've been too successful. Yes. So, so the question is, if someone's DACA expired 2015 and she came without a visa and now has a U.S. citizen boyfriend, can she get her green card? Is that basically your question? So she probably have to go through the I-601A waiver, do the visa processing in her home country. Yeah, it has to do it as a new applicant, as a new application. So, I mean, that's tough, but you can't do it under that decision. But that decision, I think, has been on hold for 90 days, right? So we don't know where that's going to be, right? Oh, yes, so yes, you can apply as a new applicant. Yes, you're 100% correct. You can apply as a new applicant, so you'd have to submit all the documentation again as to physical presence here, your high school diploma or GED. But yes, I'm sorry, you can. Well, I think again there's some confusion. She wants to know if she can apply for adjustment of status after you get DACA renewal. Well, what do we all know? No, you can't, because you have to have a legal entry. So under the old rules, DACA people could get the advanced parole, leave the country and come back in legally, and then they could adjust their status here, right? So just having DACA doesn't give you the right to apply for adjustment of status. You have to show a legal entry or parole. Okay, go ahead, Brandon. I'm sorry. Okay. You say to go to Australia. The question is, can a DACA recipient get a student visa to go to another country? Basically, that's up to the other country, right? I mean, if they want to go to Australia or New Zealand and go study there, if they qualify, I don't see, why they wouldn't give it to them, but that's up to their countries. What's that? Well, they'd be subject to the 10-year bar, correct? Right. So, I mean, if you're going to go, you're going to maybe have to go for 10 years. So, sorry. I haven't heard that one. No. The question is, the gentleman has heard that they're going through old naturalization applications to see if they maybe committed a fraud, and they could then present denaturalization proceedings. My experience is no. It's not that easy to bring a denaturalization case. They have to go through federal district court. You have to have a tremendous amount of proof. So I don't think that's what I've heard anyhow. One more and then, sure. It wouldn't be subject to the 10-year bar. Right. But generally, most people, you had to be 16 to apply for DACA. And by now already, you're probably, yeah, because I don't think DACA doesn't cure your illegal time here. Okay. So I think it still accrues. Yeah. TPS does cure it. So if you have TPS and you're legally here before you apply for the TPS, then you're not accruing illegal time. One more, and that's it. Right. Right. You're still getting the 2 years according to what the CIS is saying. Okay. everyone, thank you so much for coming, and I hope you got something out of this. Okay.
This is Dawn Pickin again, and I just want to let folks know, have other questions, feel free to reach out to myself or Brandon Kelly. He's the program coordinator for this program. I know online, Brandon has indicated he cannot answer legal advice questions, anything personal to your specific, specific situation. I would refer you back to some of the resources that we did previously that are in the presentation. We will be sending this presentation out to everyone that registered, so you will get the slides and you can refer back. And then again, just if you have questions about taking the certificate program that we offer, please come to our information session. And I did this and thought it was really important. Thank Mark and thank all